stand. But at the end of the day, after consultations, the governor herself agreed and gave her consent to taking the stand. And the break was meant also to give her an opportunity to interact with her legal team and understand what exactly she will be addressing once she takes the witness stand. 62 accusations are facing her, and according to the evidence that they have presented to counter those accusations, then it is up to the committees to see whether the evidence presented will defend her from that particular impeachment or will not merit her removal or will force her to leave her seat. The committee will be writing a report tomorrow before presenting it before the whole house on Friday. So the chair of the Special Senate Committee, as you can see, Honorable Boni Halwale, has taken his seat. Other members following right behind him, also taking their seat. Allow me to hand you over to this live broadcast brought to you by KBC in partnership with PBU, Parliamentary Broadcasting Unit. My name is Kamche Menza. Good afternoon.
Who is that guy? Very well. You can proceed.
Thank you, Chair.
Sorry, how many minutes do you want?
Chair, we had prayed for 90 minutes.
Okay.
And you had granted it.
Very well.
We will share it with my learned friend, Mr. Sheikh
Yes.
Abdikadir.
Welcome.
Mr. Harrison, is it correct that as Chief of Staff, you're part of the private staff of the governor? Is it correct, sir, that if the governor were to be impeached, you would lose the job you currently hold as Chief of Staff?
Is not correct.
Don't staff like yourself, don't their mandate terminate with the mandate of the governor in question?
No.
In the event the governor were impeached, would the new governor be entitled to appoint his own Chief of Staff?
Yes.
Therefore, you will not be the Chief of Staff.
I will not be the Chief of Staff, but I will be reassigned to other duties up to the expiry of my contract.
Yes, I'm only interested in your job as Chief of Staff. Wouldn't you lose that designation if the governor were impeached?
Yes.
Good. Wouldn't you lose the privileges that come with that designation if the governor were impeached?
Yes, I will lose.
Must it not therefore follow, sir, that even as the person you represent accuses several people of a conflict of interest, you actually have a conflict of interest in this matter?
I'm not.
Okay. You say, sir, in your affidavit, that you can speak to all the allegations, that is paragraph 3 of your affidavit, against the governor.
It's true.
You will agree with me that you're not the alter ego of the governor. Are you the alter ego of the governor, sir? I can put it in simpler terms. You and the governor are two separate and distinct human beings, correct or incorrect?
Correct.
Utterances made by the governor cannot by any stretch of imagination be your utterances.
I never talked on my utterances.
Please answer my question. The governor
They
is
cannot
accused
be.
of several utterances in various platforms. Your affidavit is you can speak to all the allegations against the governor.
Yes, I can.
Therefore, you will agree with me. Utterances by the governor, even though you are a chief of staff, are not your utterances.
It's true.
The things going on in the governor's mind at the time of making those utterances will not be also going on in your mind, correct or incorrect?
It is correct, but I need to say only God can know what goes inside someone's mind.
Fair enough. The motivations, whatever they are, in the governor doing any of the things she is alleged to have done will not be your motivations because you and the governor are different persons. Correct or incorrect?
It's correct.
You must agree with me, therefore, that you're not competent enough to respond. That is what you pleaded in paragraph 3 of your affidavit. You must agree with me, you are not competent, as you claim, to respond to all the allegations against the governor.
Through the chair, I also need to say this. When someone is represented by a lawyer like you, there is a possibility that when you get the information about what your client is for, you find that information, and even you, currently, you are engaged on the information that you got from your client, and that's why you are representing you. Because for sure, even you, I'm very sure, you cannot know what was the mind of the person or the mover of the motion. We are here as witness and to represent our client because the law allows us to do that.
Chair, since the witness will have the opportunity in re-exam to explain, I crave that you direct him to just answer my questions so that I don't take longer than the time you have allocated me.
I think a witness, that is important. Make sure that your response is directly in proportion with the question.
Noted, Chair.
The governor has faced a number of accusations, sir. Let's begin with the appointment of the husband. Is it your position, sir, the governor never made the utterances we saw on video are making?
She made the utterances.
Good. So the only difference between you and me is our interpretation of those utterances, isn't it?
Yes, through the chair, the utterances are not in dispute to any party.
So do you agree with me that the only contest between the two sides is not whether the utterances were made, but how we have interpreted them vis-a-vis how the governor has interpreted them?
It's true.
You will also agree with me, sir, that the second point of departure is not whether the utterances were made, but whether they were followed by official letters of appointment.
That's true.
Sir, would you expect people watching the governor making utterances of the type she was making to take them seriously?
Pardon?
Would you expect the ordinary citizen to take utterances by the governor seriously and specifically on their face value?
Yes, I do.
If the governor announces on national television or regional television that she has appointed her husband to some office, would you expect the ordinary rational person to take her seriously?
I expect to be taken serious. I want to add, there is no denial that she did that.
Order witness. Counsel, help us. You cannot expect the witness to testify on the opinion of other people. Limit him to his evidence and poke holes in his evidence. But to ask him now to give us an opinion on what he thinks the whole county was thinking, we shall be stretching him.
Let's come to our point of divergence on the issue whether the appointment letters were issued.
They were not.
Are you a member of the County Public Service Board, sir?
I'm not.
Are you the county secretary?
I'm not.
You must agree, therefore, you would not be the person to give the best evidence as to whether the appointment letters were issued or not.
Through the chair, I did communication to all those offices, and the letters or their responses have been attached to the response that governor gave. So my responsibility was to do an investigation, of which I did. Because I cannot be everyone, I cannot be every person, but those persons that are responsible, I did my duty, and they confirmed the same.
Chair, if my colleague could show the witness volume 2 of our battle at page 29.
Counsel, are you referring to your bundle or ours?
Ours, volume 2.
You can share yours. We do not seem to have it here.
What you have there, sir, before you is a printout of section 56. My interest is in subsection 2 of the County Governments Act. Can you read it for us?
The county public service shall be ended by a county secretary appointed under section 44.
You will agree, sir, that is the person competent to confirm to this Senate whether there is an appointment letter or not.
Through the chair, if you look at all the letters were copied to the county secretary to
That's not
confirm.
my question, sir. Based on that section, wouldn't the county secretary be the person legally qualified to tell the Senate whether or not an appointment letter was issued?
Probably it is good to differentiate between the office of the governor and the county public service. There is a difference.
I didn't ask about the differences. Please answer my question. If you don't want to answer it so that we move fast, just say you don't want to answer my question.
County secretary can confirm about the public service, but the chief of staff confirms about those that are employed in the office of the governor.
Are you aware the motion is about appointments to the county public service, not to the private office of the governor?
It is misplaced because the people that were mentioned are supposed to be those people in the office of the governor.
Let's come to the office of firefighters in the county government of Meru. Is that, would that be an appointment in the office of the governor?
Yes, it is.
I put it to you, that, sir, that it is not. There is a firefighting department. It is not an office in the private affairs of the governor like the advisors and the chief of staff like yourself.
You can confirm for Meru County is a department that was put under the office of the governor. You can confirm.
The Meru Youth Service, is it a body created by law?
Yes, it is.
Does that law specify the offices of that institution?
Yes, it is.
Now that you say there is no dispute, the appointment was declared, are the offices in the Meru Youth Service offices in the private office of the governor? Is that your testimony?
My testimony is that what you're discussing is about the appointment of the first gentleman to an existence position. So the position is nowhere. It is not either under the public service or in my office. I needed to confirm that it is not in my office because an existing position, you cannot put it anywhere.
But you confirmed the utterances were made in the rally in question, isn't it?
Yes, I confirm.
Those utterances, wouldn't they, if they were to be taken seriously, be violative of the law establishing the Meru Youth Service?
It is not related to Meru Youth Service in any way. That's my take.
To the best of your knowledge, sir, does the law establishing the Meru Youth Service have the office of patron?
It has not.
It is not.
Yes.
Still on the letters, sir, who ordinarily would be the custodian of the appointment letters if they were issued?
The Public Service Board.
The Public Service Board.
Yes.
Who else would be having possession of such a document?
Myself.
Yes.
Yes.
Who else? The appointee in question, isn't it?
Yes.
You'll agree all these are people naturally aligned to the executive arm of the government, right?
Yes.
Good. You will agree matters to do with employment and HR, the assembly will not ordinarily be in possession of appointment letters of staff of the executive.
Through the chair, the responsibility of proof lies with the county assembly because they have powers to
That's
summon
not the
everyone
question I've asked
to
you,
get
sir.
that details.
My question is, in the ordinary course of human affairs, would a stranger be in possession of HR documents like an appointment letter?
Any public document is available on request.
Good, on request. Therefore, sir, you will agree with me, there is nothing unusual in the ordinary course of events in the assembly either not having possession of the appointment letter or encountering difficulties in accessing it.
Pardon?
You will agree with me, it is not unusual for the assembly not to have in its possession appointment letters belonging to staff in the executive arm.
I don't agree because an ignorant to the privilege that you've given cannot be a defense.
Chair, again, if the witness would answer my questions, I think he's too keen. He doesn't know you'll have the opportunity I don't want to be making the interjection. Let's go to the appointment of Rufus Miriti. We've now left the husband. You will agree with me, sir, that the only contest between the two sides is not whether the appointment was made, but whether it required the approval of the assembly. Am I correct to say that?
You are correct.
Is it your case, sir, that that approval was not required?
It was not required. It was just a reappointment that has ever happened in other situations.
I will ask you, sir, to read the definition of appointment in the County Public Appointments County Assembly Approval Act. Chair, that will be at page 48 of our volume 2. Have you reached page 48, sir?
Yes.
Can you read for us the definition of appointment at section
For which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act.
So the law says an appointment for which approval is necessary shall not be made unless the approval is sought, isn't it?
It's true.
But you read section 4, you were ahead of me. I asked you to read the definition of appointment in section 2 on the same page. Please read what I asked you to read.
Appointment includes any reappointment to the same body where or not in the same capacity.
You will agree these sections, sir, show, contrary to the position you and the governor have taken, that this appointment which you concede was made actually required the approval of the assembly. By the law you've read, was that approval required?
It was required.
Good. If it was required, was it sought?
I need to emphasize on this through the chair.
Please answer my question. It's yes or no. You have agreed the approval was required. Was it obtained?
It can only be required when it is
yes or no, unless the chair rules me out of order. Was it obtained or
It
not?
was not obtained.
Good. It was not obtained. I will show you page 186. You just read the statute. We now want to see what the courts have ruled on the matter. Chair, I'm referring to volume 2 of our Bado, page 186. It's a decision, Chair, that begins at page 170, but I'm only interested in the conclusion the judge arrived at, which is at 186.
Honorable Chair, with your kind permission.
Yes, what is it?
Honorable Chair, the concern is that this witness is being taken through a course to offer opinions on positions of the law. I think that is a matter for lawyers, and he should first of all have confirmed whether he tackles or handles matters of law in the office he said he serves in the county. Now he's being told to interpret a judicial decision, which, my Lord, may not be within his competence because it's a matter of law, and any other witness, including the governor, would not have testified to that because it's not a factual matter. It's a matter of law. I think the witness is being oppressed to be required to offer a legal opinion. He has no training in law, my lord. Thank you.
Counsel, don't overprotect your witness. Your witness is a very competent man. I think what the counsel for the county assembly is asking for is not a point of law. He's not even seeking an opinion. It's a fair question. Let the answer be on record. We shall interpret it. Don't overprotect him. He's above 18.
Most obliged, sir.
Through the chair,
Even asked you the question, sir. Please read for us paragraph 105 on page 186. It's a matter about a county assembly appointment, just like the one now before us. Please read it.
paragraph
105.
It was, however, contended that since some of the petitioners had been approved by the previous assembly as the first respondent and its predecessor were exercising authority as the trustees of the people of Kenya, and more specifically the resident of Machakos County and Article 73 of the Constitution. It was thus surprising how the same constitutional body can arrive at two different reports on the same nominee for a similar job description. This issue brings to force the question as to whether the county assembly differently continued from this previous one is
I think it's constituted, sir, not continued, unless it's new.
Constituted from the previous one is bound by the decisions made by the previous assembly in approving the nominees. If this position was true, it would mean that those who were serving in the previous government would automatically qualify for approval by the assembly once nominated by the governor. With due respect, if this was the intention it would have been precisely stated in the registration. This court cannot lean in such a drastic proportion of law which is not expressly provided in Alfred Mahandi, Ngome, and others versus George W. Sitati and two others, civil application number NAI 268 of 1999. It was held that
You can even leave it there, sir. You will therefore have to agree whether it is by reading the statute or reading the case law. The appointment of Rufus Miriti required the approval of the assembly. Now that we are not in contest, the appointment was made.
that's what I want to make clear.
Now the question, would you agree, sir? Would you agree, based on the case law you've just read, based on the statute you just read, that contrary to the position you've taken, this specific appointment was illegal for want of county assembly approval?
I want to make this through the chair.
Please answer my question, sir. You will get the opportunity.
Order, counsel. Relax completely. I think the witness wants to help us. Just allow him to address the chair. Witness.
Through the chair,
Chair.
I want particularly to mention the issue of Rufus Miriti. Rufus Miriti was the county secretary for the previous government. That is the former government. when the current governor came in, she extended his term to complete the handing over that was taking place. In all the situations that you've faced, for the county secretary, who has been the custodian of the former government, you just extend some time for him to continue serving so that you can get all the resources, all the requirements, or anything that you need. And that one is allowed by the county secretary being the secretary of the transition committee that is always there to ensure that there is a smooth transition from the older government or from the former government to the current government. That is what happened. That's why there is no appointment letter for Rufus Mereti that is available, because the extension was for, that's not a reappointment, but extension, so that that time will allow the governor to form the government, and thereafter appoint a substantive county secretary that will be forwarded to the assembly for approval. That is the case. There is no letter. Is an extension that is allowed even by the transition authority, whereby the county secretary is the one that is in charge of handling matters before the governments are formed.
This idea you are now introducing from the witness box.
Counsel,
Yes.
I think the witness wanted to help us. You are helping us. Now you've boxed yourself. Do you have a letter showing that that extension was given?
The witness has confirmed, and the documents filed on the record show it is common ground. The appointment was made. What is not agreed is whether that appointment required the approval of the county assembly. The clarification the witness is now offering from the doc that this was a transitional arrangement. That is not the position taken on the pleadings. That is not the position in his affidavit or the governor's affidavit. It is a completely new position taken from the witness box, but not from the pleadings.
Chair, yeah, I sympathize with my classmate, but counsel, that is a problem you have brought upon yourself. Because after reading to the witness, the law, he is on record saying that yes, this is an appointment that required parliamentary approval or the approval of the assembly. Why you then pose the question again to him is something I don't understand. But Chair, perhaps to guide the process, because the witness has alluded to a specific time, let him tell us or tell the committee how long this appointment was and where we can find that detail in the documents that are before us.
Let the witness respond to that. We don't confuse him too much, then I'll allow you to.
Through the chair, for any acting, acting county secretary, provided that he qualifies or she qualifies to act under that capacity, you're given 6 months by law.
Yes, Senator Wandako.
Chair, I just wanted a clarification. Is the county secretary being appointed to act the county secretary that was serving in the previous term, or is a new officer?
Through the chair, is the one that was in the previous government.
My next question, Chair. County secretary served for a fixed term of office on appointment. Had the contract by the time the new county government of Meru came into office expired?
No, it had not expired.
So what was the necessity for reappointment?
The contract was for 5 years that was expiring actually on 19th of next month. That is the time that is supposed to expire.
Robert?
Yes, Chair. I just needed to get to know benefit of experience. Senator Madnago has picked on the issue. I needed to ask for clarity. Currently, is that county secretary is still serving?
Yes.
Has the same county secretary in question is the current county secretary serving, right?
Yes.
And within the contract term, is that the case?
Yes.
Okay, then what was the purpose of extension of the contract as you've discussed in that case? Because if the contract was current for the county secretary and is still serving up to now because that contract is current as per the information you've given, then what was the purpose of giving another letter of appointment or an extension for that matter?
There is no letter that was given through the chair. It's only that Her Excellency Governor confirmed through mentioning the name that because he was serving the former regime, or the former government, he is going to continue working with the current government. That's just what happened. There was no letter of appointment.
Thank you. Counsel, your witness is ahead of you. If you intended to puncture his evidence, you've made him to read the law. He has read it correctly. You have asked him how he interpreted it. He has interpreted it correctly. So you just abandon that and go to the next point.
Point. Because the position the witness has taken on the doc, I told you, is not what is on the documents.
Oh.
I want to show him the documents. Please look, sir, at page 62 of our volume 1.
Yes, I'm there.
62, chair of our volume 1. The pagination is falling on a blackened area, so it's the page after 61. That's a post by the governor, sir, right?
Yes.
Does that post indicate anywhere that the appointment of Rufus was on transitional basis? It's either yes or no.
No.
We played videos yesterday, and Chair, those videos will be Annex 3 and Annex 3A. The transcript will be at page 53 to 54 of our volume 1. In the video utterances, which we don't dispute, were made, was any clarification made that the appointment of Rufus was on transitional basis?
It was made, it was not made.
Good.
And through the chair, on the same
You
strength.
have answered my question, sir, but if the chair permits, you have no problem.
Yes, through the chair.
Order witness. Why are you volunteering information nobody wants? You've answered your question, wait for the next. Yeah.
There are some appointments, sir, which we claim were of unqualified persons including Hilary Sadi, right?
Yes.
To what position did you tell us Hilary Sadi was appointed?
Director of Communications.
Director of Communications.
Yes.
I want you to take you through the governor's documents. What was your explanation, sir? If I remind you, your explanation was just like your post as Chief Secretary. This appointment did not require the approval of the Assembly. Is that still your position?
Yes, it's true.
Please confirm Sandi was appointed at the level of directorate.
I confirm.
So this is a man who is in charge of a directorate in the Assembly, or rather in the county government, the executive side, that is.
I
Correct?
confirm.
You confirm. And as a matter of fact, your testimony was that we were erroneous because the advert we are referring to is for a junior position, isn't it?
Pardon?
Didn't you tell the committee that the document at page 76 of the Governor's Volume 2 is for a position that is subordinate to the position Sadi occupies?
It is true.
The Governor's Volume 2, Chair. It is true. Please confirm from this advert that the advert comes not from the office of the governor, but from the County Public Service Board.
That is true.
Confirm as well that the advert invites positions for several directorates within the county government of Meru.
That is true.
Please confirm one of the directorates is at page 67.
That is true.
The other directorate is at page 68 of the advert.
That is true.
There is yet another directorate at page 70, number 5.
That is true.
There is a deputy directorate, now not the directorate, at page 71.
That is true.
There is a directorate at page 73.
That is true.
There is a directorate at page 75.
That is true.
And your testimony in chief was that the position at page 76 is one pack below the directorate. Isn't it?
Yes, it's true.
Sir, I put it to you that it is self-serving for you to claim the directorate that Sadi leads is in the office of the governor, when all the other directorates, the recruiting agency, is the County Public Service Board. You cannot be a witness of the truth.
I'm witness of the truth. I produced the documents that shows Director of Communication specifically is under office of the governor. Like the case.
Which document was that? Please refer us to it.
I'll refer to document page 83 of the volume 2 of the governor's response. That is one of the positions the director, governor's press service, or director of communication, that is one of the positions that has been put by the Inter-Governmental Technical Committee, which took over from the Defiant Transition Authority.
Sir, are you aware you're referring to a different job description? This is Director, Governor's Press Service. That's not the position Sadi was appointed to.
That is the same position. Is where, for example, you can mention the position of Chief of Staff and the position of Private Secretary. That is the same position.
Chair, so that we don't have an altercation, I'm inviting you to note, because by law documents speak for themselves, from the video, from the adverts, it is Directorate of Public Communications, and the explanation the witness is offering is a completely different job description.
Continue. We've seen it on page 83.
Sir, you will also agree with me that in this advert, all persons called to apply for either directorate level or deputy directorate level must have a minimum of 5 years experience.
That is true.
You will also agree with me that Hilary Sandi does not have a minimum of 5 years experience in public affairs.
As I indicated,
either you agree or you disagree, sir.
I don't agree on that.
Good. We've had your answer, but I put it to you. Neither you, nor the governor, nor anyone has placed material before this Senate to show Hilary Sandi has 5 years experience in public affairs.
Through the chair, my responsibility from the office of the governor was to forward the name of Hilary Sandi to Public Service Board as required by law. The Public Service Board is the one that was supposed to determine whether Hilary Sandi has an experience of 5 years or not. When they give us a feedback that Hilary Sandi is qualified to be appointed as Director of Communications, we did that.
Let's go to the other illegal appointments, sir. Would you agree that all county public offices are regulated by a law?
I agree.
You will agree that if an office is to be created that doesn't exist, the mandate lies with the County Public Service Board.
Not always.
Not always.
Yes.
Sir, is a governor entitled to establish informal structures that are parallel to those that are known to the law?
No.
Good. If the law has established a body to deal with a particular aspect of public governance, is the governor allowed, whether formally through the videos we saw, or informally through the letter you say we don't have, to establish parallel structures?
She is not allowed.
She's not allowed. Would declaration of informal holders, when they are official holders of the mandate in question, undermine the functions of the persons who lawfully are empowered to discharge that function?
Through the chair, the three positions that you mentioned have never had even the governor talking about them in public or elsewhere. It is the removal motion that mentioned those positions in the motion that we are in. So,
Sir, that was not my question, and I don't want to have an altercation with you. My question was whether the establishment of parallel institutions to those known to law would undermine the discharge of the mandate of the official institutions known to the law.
Yes, it is.
Therefore, you will agree, even if we were to accept for argument's sake that there is no appointment letter, the informal declarations whose existence is not in contest was still a usurpation of the statutory and constitutional functions of the bodies mandated to deal with the various issues in the impeachment motion.
Through the chair, it is my evidence there is no informal declaration of any appointment for an existing office so that you can have parallel offices. Throughout the motion that I've read, throughout the response that I've gotten from the council or from the county assembly, there is no such declaration, whereby we have in contest of two parallel offices that are in existence. I have not known of that unless it is produced before this committee.
You are the chief of staff, sir. That's an official position, isn't it?
Yes, it is.
If the governor appointed an informal through a kamukunji or public rally, an informal chief of staff who has no appointment letter, wouldn't that interfere with your official functions?
If it is,
as
it
the
can.
legal chief of staff?
Order, counsel. Counsel. In his evidence, the witness has attached documents, evidence, confirming that those so-called appointments, they never got appointment, they are not on the payroll, the positions they were purported to have been appointed to don't exist in the county government structure. Why are you belaboring when we have so much to deal with? Why don't you...
Chair, I had not gotten to that dynamic of the problem, but I can go to it now that you direct me. Let's start, sir, with all the letters you supposedly wrote to various bodies asking to confirm. And Chair, just to answer your concern, that what I was trying to show the witness is, even if they were right on the facts that there was no appointment letter, it will still be a usurpation of the official functions.
Through the chair, I also want to confirm we went ahead and give the names, the letters of appointment of those that are currently holding the offices that have been mentioned. We revamped on that, and through the response of the governor, we've attached those are currently in those offices.
Let's look at the letter at page 51 of, Chair, I'm referring to page 51 of the Governor's Volume 2. That's a letter by Virginia, sir, isn't it?
Yes.
Has Virginia sworn any affidavit before the Senate?
No.
Has she recorded any witness statement before the Senate?
No.
This document, sir, what is the date on it?
It is on 23rd of November 2022.
And was this before or after the impeachment motion?
It was before the impeachment. It was after the impeachment motion.
Have you read the date of the impeachment motion before the Senate?
Yes.
It is 5th December. So this date, is it before or after?
It is before.
It is before. You will agree with me, sir. This is a document in response to a memo from you.
Yes,
So your memo equally, the memo being responded to, must have been in existence before the impeachment motion.
it's true.
Did you place that memo before the county assembly?
No,
Did you place this letter at page 51 before the county assembly?
no,
Sir, the answer you have given me, the two last answers, you will agree with me those answers apply to the document at page 53, correct?
it's true.
Those two answers also apply to the document at page 54, correct?
Yes,
The one at